Thank you, my lady.
Thank you. May proceed to call the matter if everybody is online.
Thank you, my lady. Today is the 14th of April, 2023, in the High Court of South Africa, Gauteng Division, Pretoria. This is a full bench third court motion heard via Microsoft Teams before the Honorable Justice Collis J, the Honorable Justice Malindi J, the Honorable Justice Mota AJ. My lady, this is case number 51735 of 2021. In the matter between African Amity, the applicants with registration number 2021/837798/06 and Zimbabwe Exemption Permit Holders Association and others versus the Minister of Home Affairs, the first respondent, Director General of Home Affairs, second respondent, President of the Republic of South Africa, third respondent, Minister in the South African Executive Government, Cabinet, the fourth respondent. Thank you, my lady.
Thank you.
If it
Please
please,
confirm your appearances. Yes.
please the court, my lady, justices, I appear on behalf of the second applicant in this matter.
As it pleases the court, Mr. Magadi and myself appear on behalf of the first and second respondent.
Thank you.
Justices, before we begin, I think it's important just to raise a few housekeeping issues that, or housekeeping practicalities. The respondents and I have had discussion, and we have agreed that prayer 4 would be abandoned without costs, prayer 4 of the notice of motion. And the respondents have also indicated to me that they would abandon their application in terms of Rule 65D3, their notice in terms of Rule 65D3, which would leave the review application and the application for declaratory order in respect of the permanent residence and the strikeout application as the matters that will be argued before court. And just,
then the applications to amend,
yes, the application to amend is also before court, lady.
sorry, it's still before court.
It is also, yes, it is. And I think just another point is that the applicant will not oppose the respondent's condemnation application. Part of the joint practice notes the respondents were to move an application for condemnation for late filing of papers last year, just to curtail, the waste of time. I just thought that we would not oppose that application.
Yeah. And you said it's prayer 4, but we still have to decide, we still have to ascertain which notice of motion are you proceeding on.
This is the notice of motion. There's an intended, understanding. There is an application to amend the current notice of motion that is before the court. So
Which one is that?
there is a, quickly.
Where does it appear in case lines? Give me the case line reference.
As the court pleases. My lady, may I do this just to save time? In my address, I will go through the sequence of litigation and refer to that specific notice of motion. It's on the 15th of March, but just to save time to go through what we need to do, I'll refer you to the exact reference in case lines of that notice of motion. But it was on the 15th of March.
Okay, that's fine. The point is I wanted to follow which prayer 4 of which notice of motion are you saying you are going to abandon now? You know, you started off by indicating to me.
Prayer 5 minutes.
Prayer 4 and 5.
No, there's prayer 4. Prayer 4.
Yes.
It's the prayer respect of the identity documents, the ID documents.
Yeah, but that's fine. That's why I wanted you to direct the court in respect of which notice of motions prayer 4 are you saying you're going to abandon during these proceedings? Hence, I wanted you to direct me to the notice of motion.
It'll be that one. I've got it here. Case lines 001D-2. Prayer 4, rather. Prayer 4. That is 001D2. It is the only notice of motion that the second applicants have filed. Because what has happened, which was important, I was going to direct the court in my address, to the sequence of litigation. The first applicant pulled out, and before the decision that is sought to be reviewed was made on the 24th of November 2021.
And that's fine. So you will have to take us through the history of the matter, because I must tell you, it was more than a challenge to understand the papers and also to understand the manner in which it's been uploaded onto case lines. Nothing actually makes sense to us. So you would have to start there. But let me just get confirmation from the respondent side, whether they are indeed abandoning the application in terms of Rule 6(4)?
Yes,
D.
yes, my lady. I confirm that we no longer persist with the point of law. Point of law relates to the standing of the association. But at that point, we're no longer proceeding with.
Thank you.
And I confirm in relation to what my learned colleague has informed the court in relation to no longer persisting with the paragraph 4 of the amended notice of motion. In other words, the application, sorry, paragraph 4 of the intended amended motion notice of motion.
Yeah, well, the heading is confusing and it's on its own. The point is, they say that is what they wish to do. I cannot record that formally yet because we still have to deal with an amendment.
Yes, yes, indeed, my lady.
That's fine. And they've also indicated to the court that they're no longer taking issue with the condemnation aspect of your affidavit.
Yes, my lady, they have so indicated, yes. We have had discussions and we did it so in order to curtail today's proceedings. We accept that the court has set for 4 days listening to arguments.
Yeah, that's fine. So are you also in agreement that we're going to have to start with this application to amend that's formally opposed by the respondents?
Yes, my lady, I do
Okay.
agree.
Thank you. All right, thank you, Mr. Chitando. If you can proceed then, and I think start off when these proceedings were first commenced in this court. Can you start there?
As the court pleases,
Thank you.
what the applicant would like to do is, first of all, deal with this, the sequence of the litigation,
That's fine.
what has been filed, and how we got here.
That's
Then what we'll then do is deal with, just very briefly, I think the most important thing would be the amendment to the notice of motion, which is the issue that is opposed by the respondents. And then after that, we'll then deal with the review application. The review application refers to 3 decisions. The 24 November 2021 decision, the 5 January 22 decision, and the 2 September 22 decision. Those 3 decisions. And the next step would then be the considering or hoping that the amendment is accepted by the Honourable Court, would be the issue of the declaratory order for the permanent residence application.
Is there any reason why this interlocutory application that's not to amend formally was not dealt with prior to today's hearing?
Yes, the application to amend was agreed when we had the discussions and we filed our pleadings leading up to today. The respondents and the applicants wanted the applications to be heard, all the interlocutory applications to be heard at the same time, not just the 65D, but also the amendment. And we thought that we'd do all of those on the same day. That was
That might have been your election, but the point is, it's not the procedure to follow in this division. Because you would appreciate there is now a full court constituted for the hearing of the, let's call it the merits of the applications. That's before court. And now this court is also now having to be detained with interlocutory applications that could have been dealt with prior to today. The interlocutory applications need not a full court to deal with it, not so.
That is so, my lady.
Yeah. And this is the challenge that we are having. We are called upon now to deal with what is really interlocutory applications at the hearing of the main application that's been enrolled here.
My lady, I appreciate that. The relief when it comes to the amendment was very small, and I won't pursue that make any of the court's life more difficult.
It's not a question of making the court's life difficult, so Mr. Chitano, I'm concerned about the time. in the voluminous nature of these applications that this court is required to deal with. And it's not the first time that the matter is before the court. Likewise, the interlocutory applications on its own could have been dealt with prior to today, so that we can deal with the merits of the application. And that is actually the procedure. If you bring an interlocutory application, such as an amendment, and there's opposition to the amendment, the rule says that you may enroll the application for adjudication. And this could have been dealt with prior to today. Now, this court is now faced to deal with that interlocutory application and give a ruling on it. And depending on the ruling that we give, the application might proceed on the merits or not. That's all I'm pointing out to you and your opponent for that matter. Interlocutory applications are not, as a matter of course, dealt with in conjunction with the main application, such as what we are faced with here. And the other challenge that we have here also is the fact that there must be a decision made on all these applications that this court was called upon to determine before the end of June.
My lady, as far as the amendment, it is just for the declaratory order. So it's just the one declaratory order. The amendment is not for the review of the 24 decision by the respondents, by the minister to end the ZE.
But there's nevertheless opposition to it. That's the point.
So what? Okay, I understand, my lady. So just to save time, it is the change really is that we are trying to move for an order that the ZEP holders can apply rather than can become. It's just those two words. It's two words. So I believe that a separate hearing, but that is what it is. We are where we are, and it is just those two words that we're trying to change. And
you might think it's a non-consequential amendment, sir, but had it been, there would be no opposition to it, because you still say it's opposed. So the court must consider that application, not so. Yes.
the court has to consider it.
I'm just pointing out, we are concerned about the fact that we are required to deal with interlocutory applications that could have been dealt with prior to today's hearing, so that we can get into the merits of the application. And by your election, you've decided not to do it in that fashion. In fact, you've enrolled, you've specifically requested that this particular application, the application to amend your notice of motion, be dealt with by this court. In other words, at the same time when the main application is to be heard. That's your election. There's a confirmation of that on case lines. And I'm saying to you, it's not a practice in this division to do it that way. It takes up time, and you can see how we only have today. And it's not that we've had time earlier during the week to deal with it. We've sat way beyond official court hours for every single day of this week to try and get through these applications. So I must minute my concern.
My apologies, my ladyship. We will not be, when it comes to the amendment concerned is not a big one. It will not, we will not take, our case is not nearly as long as the previous ones. I think that might have been a consideration what the court put us on the last day. We actually thought that it would take less time, but then it is what it is. I accept my ladyship's what my ladyship has told me, and to save more time, I think what we could do is that just briefly deal with those two words, to be and to apply. Those are the two words that are subject of the amendment. It's not. Normally one could even do it if I didn't have as much opposition. One could do it in the process of a hearing actually, and it's been done in the past. So I just. Anyway, my ladyship, that's the position, and we apologize, and to save time, we are prepared to proceed now in the order that I've said that we'd like to proceed if the court is so happy for us to proceed on that basis.
Not really happy, but I mean, I don't have a choice. So I think, Mr. Durans?
Lady, may I be permitted just to say a few things?
Yes.
I accept this is a full court and I apologize for the way, on behalf of my colleague and our attorneys, how the matter's been uploaded to case line and the way it has been litigated thus far. I accept that the full court is not called upon to deal with amendments. An amendment is an interlocutory application which is fully blown. It's not an inconsequential amendment. But in order to disrespect the court and in order, because it's a full court, may I just be given a few minutes to have a discussion with my learned colleague? Because I have been sitting for 4 days through the last 3 days during this hearing. And I'm concerned myself on the practical effect of this case. First, you're correct, my lady. You have to deal with the amendment. And an application for amendment, if that doesn't succeed, then is the originally sought in the original notes of motions differ substantially from this in the amended notes of motion. But let me just have a discussion with my learned colleague, and maybe even I can just come to an arrangement so that not to unnecessarily retain this court. We understand and we appreciate the difficulties you suffered this week in sitting through long argument.
Yeah, and then also, perhaps you can also take an instruction around the application to strike out, because there's also opposition to that, I take it.
Yes.
To strike
Yes.
out these various paragraphs contained in the replying affidavit. That's also an
Yes, it's
interlocutory
done.
that could have been dealt with
Yes.
prior to today.
Yes, please, my lady.
All right, so how much time do you need, Mr. Durand?
If you can give us about not more than 20 minutes, my lady.
All right, well, it's 10:25, so we'll reconvene at 10 to or so.
Yes, please, my lady.
Is that in order, Mr. Chitando?
That's in order, my lady. There's a court, please.
Judge Malinde and Moto?
I agree, my sister.
Yes, I also agree.
Okay, we'll reconvene at 10 to 11 or so.
Yes,
Thank
please,
you.
my lady.
There's a court, please.
My lady, I'm
Our
just,
DD.
apologies, my lady, I'm just waiting for Judge Malindi to join the platform.
Okay.
Judge Malindi will be back shortly. Thank you.
May it please the court. I confirm resumption of proceedings for case number 51735 of 2021. May it please the court.
Thank you, Mr. Chitando. I can't hear you. Just maybe check your microphone setting. Could you hear Mr. Chitando earlier on?
Not when we started now, my lady. His mic is muted. I'm trying to unmute it on my end, but I can't do it.
Mr. Chitando, can you unmute your microphone for us?
My
Is
lady,
it unmuted?
it is unmuted, but there's no sound coming from council's end.
Can you increase your volume? Is it up? Okay.
My lady, maybe council needs to log off the platform and then rejoin.
Is it going to do that?
I don't know.
Okay.
Oh,
yes,
okay.
yes. All right. Okay, we'll wait for you, Mr. Chitando. Mr. Durance, can we hear you? Maybe just
Yes,
acknowledge
yes,
that.
I can hear you. I can hear you, my lady.
Okay, thank you. It's not doing anything.
Council, are you okay to have the proceedings resume?
Can you hear me? Am I audible and visible?
Yes, yes, you are.
Okay.
May it please the court?
Thank you. I think the matter has already been recalled, Mr. Chitando.
Thank you, my lady. Thank you, justices. Apologies for the connection issue. I had discussion with my learned friend, Mr. Durance. What I propose to the court is that a very brief, and I think I can take 10 minutes just to deal with the amendment. I'll say just a few words, less than 10 minutes actually. And so we can just deal with that, just that amendment. And I apologize for the fact that the full court has to hear that. After that, my lady, what I'm proposing is just 1 hour to deal with the review application, 30 minutes to deal with the declarator application, only in the event that the amendment is granted, the declarator, only in the event that the amendment is granted, because obviously we're in the court's hands. And then in that event, only if, after Mr. Durance, if he does give an address on the merits, I'll reply to that address in 30 minutes. I'm just thinking of time, and I think that would deal with all the matters that are right now before the court. And I apologize that the court has had to deal with this amount of work so late on a Friday.
Mr. Durance, could you indicate to the court what is the position with regards to your application?
The
strikeout.
strikeout. We take the position simply, my lady. It is on the papers. If necessary, we can address you for 10 minutes, but our heads are there, and we will not belabor the point on the argument on the striking out.
Yeah, but you're still persisting with it because I asked you
Yes,
to
we're still
take
persisting.
instructions.
Yeah,
from
yes,
law.
yes, yes.
Yeah.
We're still persisting it. I took instructions.
So effectively, the parties have not really done anything. They just allocated time amongst themselves. That was also another waste of our time, I guess, eh?
No, Justice Mota, we didn't do that. My intention certainly was, given our argument there proceeded this week, and given the state of this case, and now it's pleaded here that it would not be necessary for the court to sit today. And so that is what I wanted to convey with my learned colleague. That, that's my view on how I read the case and how I see the pleadings. And I certainly think the court is entitled, in its exercise of its powers, to regulate its own proceedings, to make such an order that the matter be removed from the roll. Well, that was my intention, Justice Mota, and that still stays and that is still my view as an officer of the court.
All right.
Perhaps I must just indicate, we'll allow you to proceed, Mr. Chitando, but this court is not going to be forced to make decisions on interlocutory rulings that has serious consequences for the applicants on the one hand, and for the respondents on the other hand, on the day necessarily that we receive the arguments. Because we are a full court now that has to consider the matter and the merits of those applications. And we might not get to the merits of the applications beyond today's hearing. I think you must be appraised of it. You might say your argument is 10 minutes, but there will be a counter argument to your application to amend, and there will be a reply, and then the court will have to make a ruling. Right. So that is for both litigants that have interlocutory applications enrolled for today for consideration.
As a
I
court,
think you must both be appraised of it. We cannot be forced to make decisions instantly, so to speak, just because the parties don't think it might take long to determine the applications that's been placed before us for adjudication. So it does hold implications for you if you want us to proceed with the interlocutors before court today. You're entitled to, but as long as you're aware of it. All right.
I'm aware of that, my lady.
Okay, thank you. Can we then proceed, Judge Malindi?
Yes, we may proceed as suggested by Mr. Chitando.
Okay. Thank you, Mr. Chitando. You may proceed then.
My ladyship, as the court pleases. The application was first filed on the 12th of October 2021. Case lines reference 00, I think it's 001-1. Yes, that's right, 001-1. And then what took place was the respondent's decision, which is why we're all here, that brought us to court on the 24th of November 2021, which is subject of the review application. On 8 November 2021, the respondents filed their notice to oppose the application. There were two urgent applications, which both—
Let's just deal with this first application, the first notice of motion that was issued in October of 2021. That was not supported by an affidavit, am I correct?
It was supported by affidavit.
Where's the affidavit?
The affidavit is at 001-7.
This affidavit is not referred to in the notice of motion. The notice of motion does not make reference to the affidavit.
Apologies, my lady.
I'm saying the notice of motion does not make reference to the affidavit as it should.
The notice of motion doesn't make reference to this particular affidavit?
Yes. You have to say to the court in compliance with rule 6 that if you bring a substantive application before the court, this is the scope of the relief that you'll be seeking. And in support of the relief that you'll be seeking, you attach this affidavit that the court must consider. Now, with reference to the notice of motion, you make no such reference. So even though there's an affidavit that flows from after this document, the court does not have regard to, so it's not being referred to.
My ladyship, the party that did that was not the party that I represent.
That might be so, but you were
Yes.
cited in these papers, am I
Was
correct?
That's correct. I'll get
Yes.
to that.
And this is when you said these proceedings were launched before the court.
That is when the second applicant was cited as a party in this case.
Yes,
The
and you are saying, you're making the point that this is the point or the instance at which these proceedings were launched before the court.
Yes, this is how the case number came about and how the second applicant became a party.
Yeah. So
Before
there's no substantive application before the court then.
Yes, not on the basis of that notice of motion, my lady.
Yeah, okay, so we don't have to have regard to it then, all right? And then,
That's correct, my lady.
okay,
And that actually leads on to where I was going.
that's fine.
There were two urgent applications.
What happened next, as far as your timeline is concerned, yeah?
Timeline, okay. So the respondents filed their notice to oppose that notice of motion on the 8th of November 2021.
Mm-hmm.
They did not file an answering affidavit or any opposing papers besides the notice of motion. There were two urgent applications that were removed from the roll. The first notice of motion,
Okay, so let me just understand. So then there was a further, a next notice of motion issued, or what?
yes, for an urgent application for an interim interdict challenging the immigration directive related to the ZEP. The immigration directive was withdrawn by the respondents on the 13th of December, the day before the hearing of that matter, and the respondents still had not filed any opposing papers. They withdrew the directive, and on the basis of that withdrawal, on the 14th of December, the application was also removed from the roll.
Okay, but this application, where does the court find it on case lines? And it was issued, if I understand you correctly, under the same case number
Yes, it was.
of the previous defective application.
It was. You find it at 001A-1.
So you're saying it was issued under the same case number, am I correct?
That is correct.
This is now the interim one. Okay, was it persisted with this one?
It was withdrawn on the day because the immigration directive was withdrawn the day before. So on the 13th of December, immigration directive dealing with the bank accounts of ZDP holders and academic institutions and workplaces, that directive was withdrawn.
Where's the notice of withdrawal of this application?
I think there's a court order instead of a notice of withdrawal.
For the
It was-
court order there?
So the court order is at page, it's okay, it's case line 003-1, page 6 of the bundle, 66 of the bundle.
Did you say 003-66?
Sorry, 003-1, but page 66.
I'm trying to find it on case line, so you
Okay,
must give me the correct reference, please.
I won't refer to the page. I'll refer to the case lines. It's 003-1. I see the one is mixed up with the font in the corner, but it's 003-1. It's a court order.
This is a notice to oppose. So you say it is page 66?
No, my lady, on my on the papers in front of me, 003-1 is a court
Yeah.
order.
Mr. Chitanda, you are working with hard copies. This court is working with an electronic profile of the case.
Okay.
So if I ask you for a reference, I would want you to give me the electronic reference of where that document appears. I don't have hard copies of your case, unfortunately.
I accept that, my lady. I apologize. I think we did send a bundle, but that said, 003-1 is a case lines reference. It's not a hard copy reference.
Okay.
What we have is the
003-1.
notice to oppose.
Yes, that's what it is. It's not this so-called court order that you make reference to.
That's strange, my lady. I've got 00-31 right here. It says it's a court order. That's my 003-1.
I can't see that file, thank you.
But it says 003-1. But maybe I don't know what has gone wrong with the case.
Who was the judge?
It was Justice Ledwaba, DJP.
Yeah, that's on 003-1. I think I've got it. I don't know if you have it. It's right at the bottom. 003-1.
Oh, there's two 003s before the court, yeah. And that's part of the challenge we have here.
Yes,
Yeah.
you've got that.
It says the
Yes,
matter was removed, so it's not withdrawn,
Yeah.
it's just removed
Yeah, it
from
was
the roll.
removed. Yes. It was not
So
withdrawn.
I wanted to cross-check that. So it's not withdrawn, it's just removed. You see the reference there on the actual court order. Doesn't say it's withdrawn, it says it's removed. So it's
Says
not
it's
pending.
Yes, it was supposed to say withdrawn, but anyway. Apologies for the different references of 003. But that's what happened. And then
What happened thereafter?
so what? Another urgent was applied for in respect of the actual passports. On the 28th of December, there was an urgent application that dealt with the issue of the endorsement of the ZDP in passports.
Where does this urgent application appear in case lines? Give me the reference, please.
001C-1.
No, you won't find it there. It's 0003-1. Are you talking about the judgment by BAM, right? Justice BAM.
Justice, I was referring to the application, not
the application.
But I was going to say that the Justice BAM that gave an order in that matter.
So this is what a second urgent application issued under the same case number.
That's right.
Correct? Mhm.
And it also
What happened
said
with
to
this?
remove
What
from-
happened to this application?
it was also removed from the roll.
It's also still pending.
Yeah, it was removed from the roll, my ladyship. That's correct.
Okay, where does that order appear? I think,
So there's a 0003-2.
okay, thank you. And then what happened thereafter?
My lady, in between, there was a withdrawal of the first applicant. They withdrew at the same time that their attorneys did the first notice of motion withdrew. And that you can find. You'll find that it's, here we go. Zero 015-1.
Okay, that's just the notice of withdrawal of the attorneys.
Yes, but I think there was some duplicate pages here or something, but they withdrew at the same time together. They were their team. They left. The second applicant then made a decision to file its own paper.
Well, this was Mr. Chitando, with all due respect, this document is not a withdrawal of the first applicant. They might have made an election not to participate in the proceedings further, but this document is merely the withdrawal of the instructing attorney for the first applicant. That's all that this document purports to be. It says so.
Yeah,
It's
it is a
not
withdrawal. It is a withdrawal.
of the attorney.
I think there is a withdrawal notice. I don't know if it's in here or on case lines, but as far as I understand, the first applicant and the respondents have pleaded their case on the basis of the first applicant withdrew.
It's not on case lines. We've gone through this record. It's not here. But you can proceed. What happened thereafter?
The second applicant filed its papers
Mhm.
on the 15th of March.
Which year is this now? 2022?
March 22, they filed their papers.
Meaning,
4th.
what do you mean by they filed their papers? What do you mean?
Oh, yes, okay. They filed their affidavit, which they called a amended founding affidavit, and they also filed a notice of motion. They did not follow. They
So
didn't
they
file.
filed another notice of motion.
Yes, they did.
Okay. When that appears on case line 001, you said when we commence. 007D, I think that's what you said earlier on.
D1.
Okay, the document that you termed amended notice of motion.
It was called that, and it didn't follow the process for the rule 28. And it is important that I mention here, which is something that is part of the amendment application. The first applicant withdrew abruptly, and there was no communication between the first applicant and the second applicant after the withdrawal. It was a withdrawal after what they called intimidation. They refused to file any papers, and obviously the second applicant cannot withdraw on behalf of the first applicant. They withdrew.
Mr. Chitanda, let's just get into this document, because this is actually the document that I take it you wish to proceed on.
That
Am I
is
correct?
that is a document I wish to proceed on.
Yes, exactly.
And
So
this
you
is
say there, let's look at this document first, just to make sense of it. You're calling it an amended notice of motion. I think what you're trying to say is you wish to bring an application to amend a notice of motion. We don't know which one
Yes,
yet.
that was the intention, but it's the first. The second applicant's important. They've not filed any papers until that stage, as a confirmatory for the first applicant's application, or in any papers at all. It's the first papers that the second applicant filed.
That's fine. But you've cited them as applicants. You are the second applicant. I take it in this. You're not making reference to it, and then you say the applicant intends to make an application, and you don't identify yourself. But that must be read as a second applicant. Am I
It is
correct?
a
That's what you're saying to the court now.
It is a second applicant.
The second applicant intends to make an application.
Yes,
To amend.
the affidavit is probably more direct in that it says it's the second applicant.
All right, that's fine.
Paragraph one of
But
the-
this is your notice, and your notice, is it compliant with Rule 28? Does it comply with Rule 28?
No, the notice did not make it is non-compliant with Rule 28. They filed it, but they didn't make the intention to amend. They just said amended, but it is supposed to be it's supposed to be their founding papers, and they didn't follow Rule 28. So that is correct, which is why we're here.
Yeah, but the point is this, you know how to amend in terms of Rule 28.
Yes, there has to be an intention to amend, but that was not done by the second applicant.
Yeah, so you express your intention to amend, you set out the scope of the amendment, and you tell, more importantly, you tell your opponent, if you wish to oppose this amendment, you have to do so within 10 days of service of this application to amend on you. Failing which, you will proceed to amend the notice of motion. Now, none of this set out in this notice of motion complies with Rule 28.
That's right, my lady. The notice to Rule 28 that we are moving at the moment is made in file 2. Well, okay, it's made at. There's only one notice of intention to amend the papers before the court.
But it's this document that's referred to court.
That's not the notice of intention to amend.
So what is this document supposed to be? Because you call it an amended notice of motion.
Yes, that is the defective notice of motion that don't have in it, did not follow Rule 28. There's only one Rule 28 application before the court.
Okay, but what I want to understand is you said going a step back, Mr. Chitando, going one step back, you said to the court, the second applicant then filed their papers, and I clarified it. You said they filed another notice of motion, and that notice of motion is dated the 15th of March.
Yes, my lady, I was going through the history.
The
Sequence. I was
Fair
not.
enough.
I
So
was
this is not
saying
your
that
application to amend, you say?
Yes, that's not the application to amend.
Okay,
The
that's fine.
application to
But
amend
let's
is
just look at, let's just look at this notice to amend firstly. I mean, this notice of motion, let's not call it a notice to amend. You say you're going to the affidavit of Darlington Chiuta, Mr. Darlington Chiuta, will be used in support of this notice of motion, I take it. That's actually the correct phrase. And this affidavit of Mr. Chiuta is uploaded onto Caseline as the next document under this bundle. This affidavit was only deposed to on the 16th of March. Can I give you the reference on Caseline?
I've got it right in front of me.
Okay.
Yes.
What make of this? In other words, at the time when you say you filed your papers, as you called it, or you filed another notice of motion, the affidavit that you place reliance upon in support of that notice of motion had not been in existence. Can you see that?
Yes, my lady, what I think just to, that's going to the background, the beginning. I want to take to the rule 28 application that's before this court at the moment. That is.
We'll get to that now, sir.
Sorry, my
With
lady.
due respect, we will get to that now. And quite frankly, we have to go through this painstaking exercise now, sir, because of the manner in which these papers have been uploaded and the numerous notice of motions that have been issued here by the applicant. So before this court, unfortunately, can get into any application to amend, we need to be certain what notice of motion you wish to place reliance upon. And you are saying this is your document, not so?
It is our document.
Exactly. So please answer the court. In this notice of motion that is dated the 15th of March, 2022, you say to the court that you're going to place reliance on the affidavit of Mr. Darlington Chiuta. That's the last paragraph of this notice of motion, dated the 15th of March.
That's correct.
Yes. So I've referred you to the founding affidavit of Mr. Darlington Chiuta. This affidavit only came into being, into existence, the following day. Am I correct? The 16th of March.
Yes, it did. It did, my lady. That's right.
Yes. So can you, at the time when you filed this notice of motion, could you have placed reliance on an affidavit that had not been in existence?
My lady, the affidavit by Darlington Chiuta was dated
Yeah.
that, I think that is an issue of the day of the filing.
That's
and
not filing, it's the day of the commissioning of the affidavit.
the
Let me
commission.
take you to the page.
That's
It's
an issue.
it's 00, I want to take you to the page, sir. 001D-26, I think.
I've got it in front of me.
So that's the day that the affidavit was commissioned.
Absolutely. It was commissioned on that day, and the notice of motion is for the 15th
Yes.
of March.
So is that
So
in
the-
order?
So the notice of motion notice of motion was dated the day after the founding affidavit was commissioned. The day after the amended notice, or the notice of motion that appears on 00D1. And if I'm looking at the signatures, 00D1 dash 001D dash 26, and it appears that the date is, it's 16 March, but it was written in. There was the SABC had, I think they're the other ones commissioned the affidavit.
But
They have
it's also
to write-
stamped. It's also stamped the 16th of March,
So,
sir.
yeah,
There's a
so-
police official stamp there.
They stamped it.
Yeah.
So for me, my ladyship, well, look, if there's a typographical error on the notice of motion, that's the best I can explain it. But yeah, that's what it is. It says 16th March, and the notice of motion is dated. The 15th.
Yeah.
So the notice of motion came before the affidavit.
Yes, that's the point the court is making.
My ladyship, I think what the situation is, the notice of motion was done on one day, and then they only got the founding affidavit the next day, and
Yeah.
they're put together.
Well, I'm just pointing out to you the shortcomings in your papers. I'm not
I think
making a
that's
ruling either way. I'm just pointing it out to you. This is what this court is faced with.
Yes, I understand.
A
that.
notice of motion that is dated the 15th of March, 2022, that makes reference to an affidavit of Mr. Chiuta that only came into being the following day.
Yes. So what the
That is
notice
not
of
correct.
what the notice of motion is saying, that we're going to rely on an affidavit that's coming.
It doesn't say
what
that, sir.
Well,
That's your interpretation of it.
that's what I see has happened. There are times when notices of motion. I don't want to belabor the point, but there are times when notices of motion are filed on a Thursday, or they're signed on a Thursday, and the papers only get to be commissioned the affidavit in question gets to be commissioned the day afterwards.
That's fine.
It's not a situation where the affidavit was done before the notice of motion, and then one would be looking at, it'll raise eyebrows, but it came afterwards. So they say we're going to rely on Mr. Chiwuta's affidavit. Mr. Chiwuta's affidavit was done the day after.
Your interpretation of it. So what happened thereafter?
Well, factually, that's what happened. But anyway, yes, that's right, my lady. The day afterwards, what happened afterwards is that.
Yeah, what happened afterwards? And we know what happened the day thereafter. But after this process, what's the next step?
Filing affidavit done the day after the notice of motion, which I've seen happen quite often. It's the practicalities, but yes, after that, what took place is that the respondents filed their notice of pose, the application on the 4th of April. That application, so they filed a notice of motion to that 15 March. They filed an answering affidavit on the 30th of April, and a replying affidavit was on the 13th of September. So the three sets of papers that were set, the founding papers, the answering papers, and the September papers, were all done 15 March, 4 April, 30 April, and 13 September 2021.
Okay.
And that the notice of motion, my lady is correct, did not follow the Rule 28 process. The only Rule 28 application that's before this court is found at 07B-1.
Okay, so are you saying, albeit that this notice of amendment is non-compliant with Rule 28, the court should nevertheless entertain it today?
My ladyship, what I am moving and requesting the court to consider is that we proceed on the basis of the only application in terms of Rule 28 that is actually before the court, and that one is made at 07B1, 07B-1. And the prayers be amended in terms of that notice. And that notice is the only notice before court.
Okay, we'll get to that now. That's your application to amend now that you want the court to consider before we get into the merits of the application. There's just one other aspect that I need to raise with you, Mr. Chitanda, and this I think is very crucial. It's with reference to the replying affidavit that has been deposed to on behalf of the applicant, the second applicant here. Can I just direct you, where does that document appear in case lines? 005, you can go there. We've mentioned Mr. Chiwuta's name now several times during these proceedings, but here the deponent is somebody completely different. A Miss Sandra Chiniana. I think that's how you pronounce it. She is not the deponent to the filing affidavit that you filed in support of this application. Can you just address the court on what basis can the court consider this replying affidavit, seeing that she was not the deponent to the filing affidavit?
The deponent to the first affidavit, he was a chairperson of the organization that is before court. It's a second applicant, and he resigned because, again, of intimidation. So that's set out in I think it's set out in the content, but the replying affidavit says that the second the second applicant now has a new chairperson, that is Ms. Chianga.
Where she makes reference to her authority, that's paragraph 1 of this affidavit. She just tells us that she's a female chairperson of the second applicant
That's fine.
and duly authorized. There's no reference made that I saw that the previous chairperson had resigned. Where does this appear in that affidavit? She indicates why she has the authority to make this, to depose this affidavit, and she tells the court, the deponent to the founding affidavit, due to threats of intimidation, had to relocate to a different province. And for that reason, she's now the deponent to the replying affidavit, but there's no reference made that Mr. Chiuta was the previous chairperson and he had resigned.
Well, I think what she says in the replying affidavit is the evidence before court, which is that she's in the chairperson now for the reasons that she sets out in the affidavit.
Okay. And when was she elected the chairperson? How did this come about? There's nothing attached to the papers that proves this.
Yes, well, that is the process. The internal process is not attached to the affidavit, but that is the best available evidence that I have is in the replying affidavit, where that statement of the reasons why she had to take on that position. My lady, I think just as an officer of the court and to let the court know of everything that has been going on in the background of this matter, there's been a lot of intimidation, not just on the deponents in fact, even the deponent to the replying affidavit, she was also intimidated, and I've also been intimidated. So there's a lot of intimidation taking place, and it's a challenge to get deponents to actually,
Yeah.
permission.
All I want you to address me on is
the only explanation I have. Sorry, my lady.
Sorry, I'm saying all I wanted you to address me on is the fact that the deponent to the replying affidavit, and you concede it's not the practice for the deponent to a replying affidavit to be a completely different person to the deponent to the founding affidavit. And this is what we have here now. And the reason for that is set up in the affidavit itself is that the previous deponent had relocated to a different province. That's the only reason that's been given. And then the deponent to this affidavit now says to the court that she's the chairperson, but there's nothing more to it.
The struggle and the practical realities, my lady, in a situation like this, is what does the second applicant do? Does the second applicant stop litigating because the deponent, the chairperson, who for reasons that he has said, cannot no longer participate and hold that position because of what he's had to go through, and then someone else steps up in the association and says, I will be that person? Does that mean that they have to stop litigating? If anything,
I don't think that's the question you are being asked. I think it's a more legalistic question that we're asking you. That is that the modus operandi of these courts? If you can just admit that it is not. We understand that you might have your reasons which are not advanced in the affidavit, but it's not the norm that the founding affidavit will be commissioned by one person and the replying affidavit by another person. Is that correct? I think that's just a narrow point that my sister is making to you.
Justice, you're quite correct. That it is always, it's not just not the norm, but it is always practical to have one deponent for for the entire proceedings. But then an explanation is given as to why that could not take place. And
yeah, but
I found that's the best evidence I have, and that's the best evidence that the court has. And it is for the courts to regulate their processes, the justices.
Yeah, but you see,
And I can't further.
No, I hear you. But you see, remember, we're now dealing with something that we shouldn't be dealing with, honestly. This should have been dealt by a different court. Because if you go back to the notice of motion, which you've since abandoned, that one of 12 October 2021, you had Emma Di Maria, who commissioned that affidavit, who was the deponent. Am I right?
For the first applicant, not the second
Yes.
applicant. That's for the first applicant, not the second applicant.
Yes, but I'm just saying you had that. Emma now is no longer involved at all.
For the first applicant.
For the first
Emma's
applicant.
involved. The organization, the first applicant is not involved.
No, I hear you.
So it's not. I don't see individuals. I see it's legalistically. I see the parties before court, and Emma was never a party before court. None of the names that were being mentioned were parties before court.
So are you
So the
suggesting
first
that,
applicant.
sorry, Mr. Chitando, are you suggesting that the application was initiated without any involvement? You were just cited out of the blue? Are you suggesting that?
No, not at all, my lady. But all the applicants were going to file their papers, and then the decision was made by the
Yeah,
respondent.
well, so it's also
The
not
confidentiality
procedure,
of-
because I just wanted to place that on record. It's not procedure where there are multiple applicants or multiple founding affidavits. That's not how you bring a notice of motion before court. Because you seem to distance yourself now from the affidavit, opposed to by the deponent when the proceedings were initiated. The deponent to the founding affidavit, when the proceedings were initiated. You can't. You were cited as a second applicant, and lo and behold, you're proceeding on the very same case number with the current application.
That's why my lady. That's why there's an application to amend.
We'll get to amendment now, sir. We're dealing with the history of the matter and what has happened here.
Yes.
It's not even, I mean, it's shocking the way that this particular application, the history that this application has taken.
It's the reasons, the difficulty that I have, and I understand where the court is coming from. When the opponents say that they can't participate, but the party itself is before court, that's the best evidence I have. When the individual's name you mentioned says that I can't participate, and then the second applicant says, well, look, that individual can't participate. I'm the only person who can. That is the only explanation I have, and it's the best evidence that's before the court. That's the only evidence we have. I can't. Okay. I can't give any other evidence besides what's there. And Ms. Sandra said, Sandra Jianga said what she said, which is that she had to take that position.
All right. So you can't give us any further address. You also cannot refer us to authority that permits you to do what you've just done.
Which
So
is
the replying affidavit is supposed to be by somebody else.
the replying affidavit was deposed by. That's the only that we're in the court's hands there. It could only have been done by the deponent there, the new chairperson of the organization.
All right. Then what? So where is your notice to amend now?
It's at 07B-1. But before I go to the notice to amend, it's important that I just discuss the procedural issue on the part of the respondents. The respondents did not oppose anything that took place. They filed their papers and answered all the affidavits that were filed by the second applicant. They took procedural steps and they filed all their papers.
Yeah, well,
It's an application, so I thought that I needed to make that point, that the respondents did not oppose the fact that, for instance, there was a new chairperson for the second applicant. They didn't oppose any of those procedural irregularities. or any procedural irregularity at all. They filed the entire defense based on all the papers that we
No.
submitted.
I take the point. So you're saying that they didn't bring an application in terms of Rule 30 to say
They
this
didn't-
is irregular.
they
I
didn't-
take the point.
Yes,
But it
And-
doesn't preclude the court from raising it with you because you're the applicant before court.
absolutely. I just thought I
Yes.
needed to mention the fact that they didn't.
Yeah, no,
They
we're
took-
aware that they didn't.
They
They
took pleas of-
didn't proceed with Rule 30. We're aware of that. All right, let's just get to your amendment now, because I think that's where we are at now. Am I correct?
Yes, my
Your
lady.
application to
Before I-
amend.
Before I do that, I just want to make submissions I think are helpful to the applicant.
Okay,
Not only did they not make those any objection to all the papers that were filed, they responded with an answering affidavit, and to date they filed 2 heads of argument.
I don't think whether that is actually correct, because there is a rule 28 sub 3 where they set out the basis upon which they object to the proposed amendment before court.
There's a notice to oppose the amendment. I'm saying, my lady, before we get to that notice to oppose, the notice to oppose the amendment or even the amendment application itself, there is the respondents filed all their papers.
Yeah,
Every-
you've made that point already, sir. You've
So-
told the court
so-
there's 3 sets of affidavits as before the court, and you gave the court the dates when these affidavits were filed.
Yes, so
You said 30th of April 2022, the answering affidavit, and the reply was 13th of September.
as a court pleases.
Yeah, so we're way past that point. We're dealing now with the amendment, and you want to take us back to that.
No, not at all.
Okay.
I was about to make a submission
No.
that it's written here, that there's no prejudice at all to them on that regard. So now I'd like to take, with the court's leave, I'd like to refer the court to the heads of argument that were filed that deals with the amendments. But you'll find that at case lines reference 23-50. It's under the headline amendments, paragraph 151, and it goes to paragraph 2354. Sorry, the case line reference 2354. So 23-50 to 23-54.
Okay, so this is your heads of arguments in respect to the amendment.
Yes, that's right.
Yeah, okay, but I would like you to take us through the amendment itself. You can reference
Okay.
it to your heads, but I'm more interested in the amendment itself, sir.
Okay.
I need to understand this amendment.
So what the amendment seeks to do, my lady, in short, is review the decisions on the 24. Okay, let's quickly.
24th November 2021.
So Melody, I'm just getting there. Yes, I'm there.
Yes, thank you.
So, okay, prayer one, what they would like, what the applicants would like prayer one to read is that the respondent's 24 November 2021 decision to end the Zimbabwean special dispensation, providing a 12-month grace period at the expiring of the current ZEP, which invites the holders of ZEP to apply for permits appropriate to the particular status or situation during the 12-month period, and ordering unsuccessful applicants for other permits to leave South Africa or be deported is reviewed, set aside, declared unlawful, unconstitutional, and invalid. That's what the applicants seek for that prayer. It says remain the same, but what it obviously because of that issue of the first one, which is the 15th March, which is the problem. But that's what what the applicants would like prayer one to read. What the applicants would like prayer two to read is that the respondents' 5 January 2022 decision to extend the ZEP for 12 months and 2 September 2022 decision to extend the ZEP for 6 months, together with reasons provided is reviewed, set aside, declared unlawful, unconstitutional, invalid. The applicants would also like prayer two to read, declaring that law-abiding ZEP holders have a legitimate expectation to apply for permanent residence in the Republic of South Africa. Prayer four is unnecessary at this stage. That is what the applicants seek. The respondents have filed, and I think it's important that I mention the respondents' second or supplementary heads of argument, which deals with the issue of the extension, sorry, the amendment. If I can direct the court to the paragraph 129 of no, yeah, it will be the respondent's supplementary effort, supplement heads of argument, which is at case lines 30. 30 dash, well, I'm looking at 30 dash 47. Apologies, it's 30-7. I'll read it. It says these supplementary heads address the merits of the amended relief sought by the association on the premise of the amendments sought by the association being granted. I repeat, on the premise of the amendments sought by the association being granted. In the event that the amendments are granted and it is necessary for the Minister and the Director General to make submissions on the amended relief. So the respondents have filed a heads of argument that deals with exactly what is out in the notice in terms of Rule 28. And they're comprehensive. The court have noted that I think they're 53 pages, or 54 pages.
Can I just find out your 28.4, which is on 07B-1. Am I right?
Sorry, my lord, I might have the different reference. Could you please say that again? 07?
07 capital B dash 1.
I have 07A-1, but I think it's the same document. I think if you're referring to the notice in terms of Rule 28, it's the same. It would be the same.
The same document.
I think so.
Yeah, my question is, is it in compliance with 28? Let's go to your, you see, I have a lot of problems with how this was gone about. Number one, even the notice of motion itself, it's referred to in a different quaint way. It's a notice to amend, right? I don't know what that means, but I guess we've taken that it's your notice of motion because you're saying it represents the second applicant. So I must forget about the first applicant because even Emma is for the first applicant, doesn't concern you. All right, these are some of the issues that I have in the back of my mind. Now we move to the amendment. Now we're talking about you because it's easy to say these other matters did not involve you. You know, you are now involved in this matter. You, as a Chitando, am I right? On 28. So I assume that 28 was drafted by you. Am I correct?
Yes, it was. So
it was.
Notice of intention to amend, not notice to amend, my Justice.
Yes, your 28.4 that is on 07B-1, is that your document?
I have, Justice, I think there might be.
Yeah, but we know we're talking about the same document.
I might not be. I wanted just to be sure, just in case I make a mistake. I think we are, but I just want to be sure. So
Yeah.
Don't get into any trouble. My Rule 7A-1, it says, notice of intention to amend. Be pleased to take notice that the applicant intends to amend its notice of motion as follows. Prayer
Yes.
1. Is that I'm afraid that there might be cross links on
Right.
the.
Mine starts with prayer 3. So
no.
deleting the law binding, is that the one?
No. I think we're looking at two different documents. I think that's important that I.
Okay, which document are you looking at? Direct me to that document.
Justice, I have a notice of intention to amend 07A-1, and it says notice of intention to amend. It starts with prayer 1 and does not refer to prayer 3 or any other.
Yeah, but what I'm referring to is notice in terms of Rule 28.4 of the Uniform Rules. Do you have that?
Yeah, I think the point is this. When you give, Mr. Chitanda, please try and follow here. Right. When you give notice of an intention to amend any document before court or a pleading, you have to give notice to your opponent, set out the scope of the amendment, give them an opportunity to oppose it within 10 court days, and inform them if they do not file opposition to it, the amendment will be so affected. But the point is this, the notice that you send out must speak to the enrollment of that application if it is to be opposed. And this is the challenge that we are facing here. Your notice in terms of 28 sub 4 is bringing this application, the opposed application, to amend before court today. You want this court to adjudicate that. And the two documents must speak to the same thing. This is where the challenge is. Judge Mota is pointing out to you that the notice in terms of 28 sub 4 is not speaking to your application to amend. And this is what we want you to follow.
I think
Because you talked earlier on, you talked about a pre 1, a pre 2, and a pre 3, and you read it out to the court even. The document that is in the tram line referred to as amended notice of motion, which is actually supposed to read your application to amend in terms of 28. What? That's what it was supposed to read, but you called it an amended notice of motion. All right, that document must speak to the application that you want the court to consider in terms of Rule 28 sub 4 now. And it does not seem to speak to the same document. So can you clarify this to the court, please? Because it's a challenge. We cannot adjudicate an application to amend if you don't even follow the papers that's before us. So please clarify it to the court. So your application to amend, you've said to the court on case lines, it's 07 capital B,
07A.
not B.
No, no. I think that's the problem. I think we are looking at two different documents. I'm afraid we're looking at two different documents. And I think that's why there's a misunderstanding. Because the notice of intention to amend that I have in front of me does mention the exact specifics. Well, I think, unless there's, there might be a problem with.
Chitando, can you go to 07 capital B? Can you go to the document on case lines, please? That's the application that brings you before court today for the amendment.
My lady, may I do this? I think it's important that I get clarity on this particular, if there are two. I don't think there are. I think there's one, or there's a problem, a page missing. I want to get clarity. So may I just quickly get an instruction quickly on that?
Well, once you're getting clarity on that, even if I were to be generous and benevolent on the facts that you presented and look at the document, which is 7, you say it's 07A-1. Right. Is it also in compliant with 28.2? It's not also in compliant with 28.2. Now leave everything else and let me look at the document you are referring us to now. Say we didn't have sight of that. Just a cursory look at it. It's not in compliant with 28.2. Look at 28.2. What does it say?
Justice, what I'll do is I'll take an instruction on that point, and I'll come back and I want to understand why there's a 7A and a 7B. That's also important for me.
All right.
Because I didn't know that. May I come back in 5 minutes? 5 minutes.
I think we can take a 15-minute adjournment because we haven't had an adjournment during tea. Thank you. So we'll reconvene at 12:15. Advocate Durance, is that in order?
That's in order, my lady. I don't have any objection to it.
Okay, thank you.
Yes, please.
Thank you, Tipu. Are we ready?
Apologies, my lady. My lady, I'm just waiting to confirm if the judges are online.
Okay, thank you. Let me know.
I will do so, Judge Collins. May it please the court.
Thank you.
I confirm resumption of proceedings for case number 51735 of 2021. May it please the court.
Thank you, Mr. Chitando. Are you online?
I am online, my lady.
Yeah, thank you.
I thank you and I'd like to thank the court for giving that opportunity to get clarity, which I've got.
Thank you.
My instructing attorney just told me what has actually happened.
Oh,
I think it's created confusion. Just as a point, I think justice is the 28 notice 28.2 was not complied with. Doesn't say that doesn't give the respondents 10 days to respond to the amendment. That's correct. What has actually taken place was, notwithstanding that, the respondents filed an objection to the notice, the Rule 28 notice, within 10 days. So they got the notice to amend, and they filed an objection. I think that's at 078-1. and it was done on 22 September 2022. So the Rule 28 notice sets out the review application. It sets out the various prayers that I think I read into court earlier, and that was done. That was then proceeded rather with an objection, and objection set out the reasons why the objection was made, and also the heads of argument, both heads of argument, the respondents, excuse me, the respondents have filed 2 sets of deal with the amendment. I think it's important I just make the reference. It's at the 7A-1, 13 September. And then there's there is an amendment, a 7B-1, only for paragraph 3. And from what my instructing attorney has told me, that the respondents have not filed a objection to that, which clarifies the confusion, to that proposed amendment, intention to amend. I would like to make just a very quick single statement on.
Can we just get clarification, please, Mr. Chitanda? Is the notice to amend under 07 capital B?
Sorry, there is a notice of intention to amend at 07A-1. That deals with all the prayers. There's a notice of intention to amend at 07B-1 on 10 October 2023.
Well, just give us some time to find the documents. It's quite a challenge to find these documents on case lines, huh? So 07A, that's the notice to amend you wish to proceed with.
That's the one that was objected to, and in fact, both of them deal with. Sorry, are dealt with in argument, heads of argument by the respondent. But there is a notice to oppose that amendment that was filed by the respondents after 9 days. They had 10 days to do so in terms of Rule 28(2), but they did so within 9 days, within the time allocated.
So the notice to amend in terms of that was filed under 07 capital A, that's the one you say that there was formal objection raised in respect of, that brings you before court today. Is that what you're saying?
That is, yeah, that is what I'm saying, my lady. That's what I have in front of me.
Okay, then you make reference that there was another notice to amend.
Yes,
But there was no objection raised to that.
no objection has been raised to that.
Where does that document appear?
I think it's at 7B. That's the 7B-1 that I think Justice Motta had referred to. I think that's where we were confused.
07B.
Yeah, or 7B-1.
7B.
Yes, my lady. That only deals with paragraph 3, I think. Or prayer 3.
Where is it uploaded under case lines? On the case line platform, I can't find that document. Where is it uploaded on case lines?
I'm told 7B-1. Double check.
Yeah, it's there on 07 capital B.
No, he doesn't say 0. He says 7B. I asked him. He says 7B.
No, it's 0.
I said both interchangeably. I apologize, my lady. I said both interchangeably. I apologize.
So it's 07B.
07B-1.
Thank you. Well, this is not a notice to amend. This is now an enrollment, so to speak, for the application to amend. The application that's opposed.
Yes, I think,
That's what this document is. It's not another application to amend. This is in fact your enrollment for an opposed application to an amendment. That's what this is.
okay. So apologies, my lady. So it's actually 07A-1. That is you're quite right, my lady.
So where's this other application to amend, you say? Where does that appear? The second one that you say is not opposed by the respondent.
No, that was, I think that was the confusion. That is a document that, sorry, the 07A is the notice, the application for amendment.
Okay.
Yeah.
All right, now let's deal with it then. Well, it's incorrect when you say you wish to amend your amended notice of motion. It's not been amended, am I correct?
No, it has not been amended. No,
Yeah.
that's why we're
So
here.
So you wish to move an amendment now, today?
Yeah, that's why we're here. That's right, my lady.
Okay, all right, proceed then with it.
The reasons why there have been so many amendments throughout is because of the decisions. A lot of decisions were made from the beginning, from the first decision, which was the decision that was made on the 24th of November 2021 to end the ZEP. And then there was the challenges to directives, that some directives one directive was removed. There was another decision on the 5th of January to extend.
I think the way we would prefer you to deal with it, Mr. Chitando, deal with the actual amendment, deal with the objection raised to this proposed amendment by the respondents. And then you move to the next amendment. Do you understand? That's how we're going to follow the basis. So don't just talk in general terms. We need to follow the actual amendment point by point. Do you understand?
Yes, I understand. I already read out I didn't want to read out again, but I understand that I already read out the intended amendment.
No, you've read that one out, but what's the ground of the objection?
Well,
Because you have an opportunity now to respond.
okay. The respondents have complained about the objection. They say that, well, in respect of the review application, I believe what they're saying is that the applicants have made several changes, and our argument is that we had to make those changes because the respondents were making the decisions that they were making. They made decisions on the ground to make the extensions, for instance. The issue of the extensions are important because what it does is it holds the ZEP holders in a situation where the conditions are kept alive, and the conditions include that they cannot apply for permanent residency. So we had to challenge those extensions, and the respondents are arguing, you've made a lot of changes, and our response is we had to. That is the most important point that I'd like to make in regards to dealing with the objections that are made by the respondents. The objection dealing with, I think the most important objection deals with the application or the declarator that deals with the application for permanent residence. That change that we are seeking is that ZEP holders ought to have the right to apply for permanent residence. It's the part of it, and not to be. That is the change, those two words that we're seeking to make. And the respondents have said that in their objection, they say that it's in the heads of argument I think it's in both sets of heads of argument. They say that it creates a different cause of action. And our response is set out in the heads of argument. It says that, no, look, the only way one can become a permanent resident or get any permit or visa in the country is through an application. It doesn't come about automatically. It requires one to make an application. So what we did is that we changed those two words. And the respondents said that it changes the cause of action, and we said it doesn't. In fact, the evidence that the applicants will rely on in the declaratory relief that is sought is the respondents' own admissions. And the admissions are very simple. They admit that ZEP holders have been in the country since 2009 on this program. And that is the key admission. It's the only one. And the rest is just application of law. What does Section 25, Section 26, Section 27, Section 31, 2B of the Immigration Act say? And in respect of those provisions in the Immigration Act, when one looks at the admissions that the respondents have made, our case for the declaratory relief is made. So we're not relying on any new evidence. We're not changing the cause of action. We're just making that change from to become, rather to apply to become, rather. That's the change that we wish to make.
Paragraph 3 of the notice of motion. I'm dealing with the objection now because I need to follow this one. Paragraph 3, the respondent sets out here, sorry, this is in respect of the objection also. The respondent sets out that 007 capital A, that's the objection in terms of Rule 28. So in respect of paragraph 3, the respondent sets out, now you wish to have a declaratory order by the court to permit the Zimbabwean exemption permit holders to be permanent residents in this republic. Is that what you're seeking here?
No, it's to apply. I think there's confusion there. We're seeking to apply. And even in the heads of argument from the respondents several times, that is the relief that's how they argued their opposition to the relief that we're seeking, which is the right to apply.
But in your notice, you never said you wish to have the right to reply. You're saying you're seeking a declaratory in paragraph 3, declaring that law-abiding Zimbabwean exemption permit holders have a legitimate expectation to be permanent residents of the Republic of South Africa.
My lady, I think I know what has happened. That notice, I think there's the 7B notice, 07B1. I'm just getting an instruction here. I had mentioned that there were 2, but the paragraph, the one that Justice Mota had said that deals with paragraph 3, that is the one where it says to become, to be, not to apply, not to be. That's the one that's at 07B1.
Before you take instructions,
can I please take? I think there's what has happened is I think case lines is confused us the numbering automatic. But
I told you the case lines has confused you.
The
issue is how these documents were uploaded, but I think Judge Malindi wanted to ask a question.
How it was
Judge
uploaded.
Malindi?
Issue.
Thank you, my sister.
Because I think
Just a second, Mr. Chitando, Judge Malindi just want to pose a question to you.
Mr. Chitando, can you go to 07 capital B -2?
As we're doing this, Justice, I'm relying on feedback as I go through the case lines. So give me a moment as it comes to me. because
Yes.
I've got it here, because I've got several screens in front of me to deal with everything.
Yes.
Justices, in regards to paragraph 3, which is the PR, where I think we've discussed the review. May I quickly make a call? I think there's two different documents coming at me on the same, using the same case lines reference. May I quickly?
Okay. Before you do that, I'm looking at your Rule 28.4 notice in terms of Rule 28.4. Do you have it anywhere in front of you?
I have it, the hard copy here, but I'm also
Yes.
looking at what I'm being sent. So
Okay.
may I please ask what to get that clarity on that issue?
Okay, you have it in front of you on a hard copy.
But a hard copy of everything.
Yes, it starts with prayer 3, isn't it?
Which notice is this? What's the reference? Sorry, Justice Malindi, the case line reference that you have?
No, the case line reference that I have is 07 capital B for baby -1.
-1.
It's here.
You said you have a hard copy of your Rule 28.4 in front of you, isn't it? That we are moving today.
Yeah, I've got a hard copy of the Rule 28 that we had filed, the one I'd mentioned, but I'm afraid that there might be some confusion.
Or not? Just
But
wait before.
I wanted to call to clarify that.
No. Let's see if we are looking at the same document first. On the first page, it has prayer 3, and then below that it says deleting. Is that correct?
That's correct.
And then on the second page, it says adding.
Yes.
Now, where it says adding, after the words, second line, after the words expectation to, can you see that?
Yes, I do.
You are moving for the substitution of the word apply. Is that correct?
We want to apply to say that the ZDP holders have the right to apply for permanent residency.
Yes. So what you are moving today is to add the word or words apply for, okay, instead of what is in your notice of intention to amend, which, if one looks at prayer 3, reads expectation to be permanent. Is that correct?
That's correct.
Yes. So in terms of your notice of intention to amend, you sought to delete the words be, okay, and to be substituted with the words to apply, those 2 words.
That's correct.
So that is what we are here about today. Is that correct?
As far as that paragraph, that's right.
Yes. And the respondents objected to that at 007 capital A-1. Is that correct?
That is correct, Justice. Not just in the notice, but in the heads of argument as well.
In the heads of argument. Now, my learned sister has invited you to address us as to why you seek that amendment to put the words apply to instead of the original word be. And so if you may address us on that, and of course, you've referred us to their objections, tell us why they object to it and why their objection should not be upheld. Are we agreed now on the procedure?
We are agreed, Justice. And I think that is dealt with in heads of argument, but I'll deal with it.
Thank you, my sister. If that clarifies the question you were dealing with Mr. Chitando, I have no further discussion with Mr.
Yes,
Chitando.
thank you. Thank you, Judge Malende. I want him to present his argument around this particular amendment on point.
Okay. This amendment is dealt with in heads of argument. I want to give the correct reference on case lines. I've got a large number of papers here. Dealing with the reasons why why the second applicant wants to change to apply to B, and it has to deal with the practicalities of such an order and the realities of how one gets any visa or permit in the Republic. Every visa, every permit, not just a permanent residence application, any documentation within the Republic requires an application. No one as of a right, and that is common force. No one as of a right becomes anything without an application. So you apply for either a permanent residence permit, apply for a temporary residence permit, whatever it is, there has to be an application process. So to become anything, you have to apply. And the submission that we made in our heads of argument, I'm going to quickly find it. Also, today we filed supplementary heads in response to the respondents' supplementary heads. But the only way, as I've said, that anyone gets a visa permit is through an application process. So by amending that prayer, what that does is it deals with practicalities. The respondents raise various challenges to permanent residency. One of them deals with that issue, the application process. Whether ZEP holders had a condition that they could not apply for permanent residency during the currency of the ZEP. So what we're doing is we're dealing with a grammatical change.
Yeah, but why do you need a declarator for this? That's what I want to hear you on. Because you want this court to issue you with a declarator that the Zimbabwean exemption permit holders have a legitimate expectation to apply.
Yes.
Why do you need a declarator? They can do it now, not so.
No, they can't. That's part of that is the merits of the case. I'm trying to avoid going into the merits. The conditions say that they can't, and in argument, the respondents say that they can't. can't do it. They're not allowed to apply for permanent residency. And that, as I said, we're now dealing with the merits, and I think that in part informed the applicant's position of dealing with them in the merits. But it's a prohibition. They're not allowed in terms of the ZEP. They cannot apply for permanent residency.
Yes.
Anything else on this one?
Um,
This particular prayer?
This particular prayer just deals is I think I've dealt with it. What the change to deal with the merit. The rest is the merits. I'll now be dealing with the merits of the PR application, which I can do now. But I think that is the only issue. It's just a change to apply, not to be. That's all.
The rest of the amendment?
There's that I would like to address. The prayer 4 is no longer before the court. So it's the review application as I read it out.
Sorry, this is prayer 3 that you've dealt with now.
Yes, prayer
Prayer
4.
4, you say you're not proceeding with.
Yes, that is.
Prayer 2,
Prayer 2 is the extensions.
But in terms, Mr. Chitando, in terms of your Rule 28.4, we are only confining yourself to prayer 3 and prayer 4 has been abandoned.
Yes.
Am I correct?
Yes, prayer 4 has been abandoned. At the moment, it's just the review application and the declaratory on the permit residence. That's it. That's all that we like.
Okay, let's just talk about your Rule 28.4. Your Rule 28.4, as we have it now, is only prayer 3 that you wish to address us on in terms of the amendment.
And not the review. No, that's right. The identity document has been abandoned, and I've given prayer 3's argument on the change of the to apply.
Okay, we are not talking about your notice of motion. You'll address us on your prayers, but in terms of Rule 28 brackets 4, you are only moving an amendment to prayer 3 by substituting the word be with the words apply for.
That is correct. That is correct.
Yes. So your application to amend is now concluded, isn't it?
On that issue, yes, Justice. Before I go, I'm getting notes, messages from my instructing attorney. I would like to just, before I conclude, to hear if there's another point or something I might have missed. May I?
can I take an instruction?
I'd like to take an instruction quickly.
How long will this take, Mr. Chitanda? We're almost in the lunch and adjournment, so
2 minutes.
shall we not take it now and maybe resume slightly earlier?
I'm in the court's hands. I'm here all day. I'm in the court's hands.
The thing is, we don't want to adjourn now and, waste this
Minute.
10 minutes or so.
I'll be 2 minutes. I just need to answer what I'm receiving.
Okay, take it 2 minutes, then I take it. We'll wait for you.
As the court pleases.
Thank you, Mr. Chitanda.
Are you ready to proceed, Counsel? 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 Advocate Chitandu?
Going on.
Counsel, are you ready to proceed?
Hello, am I audible?
Yes, you are, Counsel. I'm trying to find out if I should alert the judges that you're ready to proceed.
And speak to the board.
Hello, am I audible?
You are, Counsel. Counsel, can you hear me?
Am I audible and visible?
Sorry, Depo, I don't know. Are the judges online and Mr. Durance?
My lady, the judges are online, as well as Advocate Durance.
Mr. Chitando, can you hear us?
Am I audible?
My lady, council just sent a text on the platform saying I cannot hear proceedings.
All right, I think perhaps it's a convenient time to take the lunch and adjournment, and maybe Mr. Chitanda can sort out his connectivity during that period. Mr. Durance, can we take the lunch and adjournment now, and then we can reconvene it at 2 o'clock?
Please, my lady.
All right, thank you. Please try and contact Advocate Chitanda.
I will
Okay.
do so, my lady.
Establish his connectivity. Thank you.
Thank you. Sorry for hanging up. Can you hear me now, council?
I was going to speak to you, but please switch off the mic.
Okay.
Sorry?
Okay, what about now?
Try speak on the platform.
Okay, then. All right, then, bye.
Yes, Council. Advocate Chitando.
Hello?
Can you please switch on the mic? I want to make sure that I can actually hear you because I was speaking to you, but then I wasn't sure if you could really hear me.
No, my mic is on, eh?
Okay, then please hang up so we can try talking on the platform.
Okay.
Council. Can you hear me, Council?
Can't hear you. I can't hear. Can't hear. Hello?
My brother.
Yeah.
Just mute your sound.
Advocate Chitando. Yeah. Advocate Chitando. Advocate Chitando. Advocate Chitando. Please unmute yourself if you can hear me.
Council,
Can you hear me? And can you see me?
Council, I can see you, I can hear you. Can you hear me or can you see me?
I cannot see you, but I can hear you. Can you?
Okay,
Okay, perfect. Thank you. Got it. Thank you.
all right. Please check, Council, if you can hear before.
Council, can you hear me?
I can hear you, but I can't see you.
No, my camera is turned off.
Okay, that's fine. All right.
Thank you.
All right. Thank you. Okay, bye.
Thank you, my lady.
Thank you. You see me, sorry?
No, Judge.
Can you not see me now?
Still not, Judge. I'm coming out, Judge.
I don't know what to do. I came on as a sign and I switched over, then I took it to there and then I took it back. I don't know what to do. I never touched this device, I must tell you. I'm working on those devices very much. But I left the proceedings. Together. Turn it to your side, please. You sit there and look on it. I don't see myself in I'm not in. Can only hear. So which one? Is this a link?
Yes.
Shall we say join through browser?
We can try it. It's still gonna take us to the same. Thank you, my lady. I confirm resumption of proceedings for case number 51735 of 2021. Thank you, my lady.
Thank you. Can the parties hear me?
I can hear you, my lady.
All right, we're going to proceed. In the meantime, I'm using my registrar's device, so we don't waste unnecessary time until such time as the IT technician comes out to sort out my laptop.
As a
All
court,
right. Thank you. Say, I take it that was your argument on your amendment, Mr. Chitando.
before what I was saying before was that I was going to consult with my certain attorney, and I did so, and that was the argument. There's the respondents did not oppose the amendment in regards to the review application. They only opposed the amendments regards to the declarators, the two declarators. No, it's just one declarator, because we let go of the other.
Okay.
My lady, may I apologize? I'm using my cell phone now. I have a similar situation to you. My device, I don't know what happened. There was load shedding, and it affected the Wi-Fi, and I can't get on my laptop anymore. So I'm using my cell phone, and if the phone does ring with people calling me, I apologize if I keep touching the screen to decline.
Okay. No problem. Can we find out, Judge Malindi, do you have any questions to Mr. Chitando?
None, my sister. Thank you.
Thank you. Judge Mota?
Yeah, just one question which relates to your, I think it's prayer 3, which deals with the application and B, changing those words, right?
That's right.
Yeah. The problem I have, you locate it in your 28.4, and your 28.4 is your application. In your notice of motion proper, you don't find it. You with me, right?
The notice of intention to amend, or I didn't understand.
Yes, I think we can agree that 79A is your notice, sorry, 07A is your notice to amend, right?
Notice of intention to amend.
Yes. It does not have what your 077B has. And your 7B is your 28.4, your application.
That is the actual application.
Yes.
I think that what I've picked up, there might be a typographical error or something in regards to that. So what I'm suggesting, my justice, and also in regards to time, I'm considering following the matter along these lines. The review application is, insofar as the amendment is concerned, that is not opposed or not objected to. Even in the 28.4. So what I'm in regards to time, what I'm proposing is that the applicants, considering the time of day, move the review application, because that's not opposed. It was not objected to by the respondents when they filed the objections. The only
So are you suggesting that you are also abandoning your 3, your prayer 3? Then you just proceed on the review application.
Okay. We'll proceed on the review application. Insofar as we would like, obviously, to have an opportunity, given the time of the day, see what we can do with the 3. But I think what
No, but I'm addressing 3 because your 3 is not properly located under your 28.
Two.
It's only located in your 28.4, which is your application, and we agreed that it can be correct.
What Justice, what has happened is that the respondents, when they filed their papers, even after the 28.2 and the 28.4, they filed their heads of argument to deal with that change. So they know about it. They've made procedural steps. They've picked those type of practical errors, or they accepted them. So they filed papers. My learned friend for
Well, we'll hear from them. We'll hear from them,
but
if they're not prejudiced by that.
Yeah, but our position is they're not prejudiced. They know what we are trying to say. In fact, their argument deals with applied to be. Yes. So, but insofar as the court is not prepared to accept that amendment, there is no review application, and we're prepared to proceed on that immediately. And I will also submit that there is no prejudice to the respondents. They've filed all their papers, hundreds of papers, to deal with that amendment and the merits and how it changes the merits as well.
I have no further questions, my sister.
Thank you, Judge Morton. Mr. Durance?
As it pleases my lady, I'm not going to be long. I've been following the debate today. But I think for present purposes, my lady, one should start at this argument for amendment. One should look at what is Lordship Justice Mota referred to, is the notice under case line 07 capital A. That is what my learned friend calls a notice of intention to amend. If one has regard to the notice, because the question here is, which notice of motion is the applicant seeking to amend? And in its notice of motion, it makes it, in its notice of intention to amend at 07 capital A, case lines -1. It is clear that the intent to amend, it's seeking an amendment of its amended notice of motion. So which amended notice of motion is that? The amended notice of motion referred to in that notice can only be the amended notice of motion found on case lines 001 capital B-1. And that is that the respondents, pre-1, that the respondents 20 November 21 decision, it's a press 1, press 2, press 3, and press 4. And what my learned colleague has been debating with this court is the amendment of this notice, and press 3 in particular. But my learned colleague conveniently forgets that he had earlier submitted to this court that this amended notice of motion, which he seeks to amend, has not been properly amended. He said he considered it outright. There is no steps taken in terms of Rule 28 to have this notice of motion, to have the notice of motion amended. So if one goes to case line 001-1, that is the first notice, or original notice of motion dated 14 October 2021. That is, as my learned colleague had pointed out, an application that was brought by African Amity, NPC, and the Zimbabwe exemption permit holders and various other applicants. So the African Amity and Zimbabwe exemption permit holders or issued this application, or parties to this application, and it's makes no use for it doesn't make any sense, serves no purpose for my learned colleague to address the court and say the application was withdrawn and then we had to file and amend it. We filed in papers. The fact of the matter is the application was issued under Rule 7, the authorities under Rule 7, 1 says, it's the attorney that should be authorized. And we know that once the application has been issued, the attorney has been authorized. So the applicants are stuck with this notice of motion. So the applicant faced a difficulty, Mr. Chitando's clients faced a difficulty. It's when one of the other applicants withdrew this application, and then they thought to deem it prudent or wise to file the papers under 001 capital B, that is the amended notice of motion and the so-called amended affidavit. But we submit that, and my learned colleague has painstakingly, as the court asked him to, unsuccessfully show the history of the matter. What we know, there's an original notice of motion, and this is the one on 001. Then there's various applications, urgent applications, 2 applications, which has been removed or withdrawn, but except for present purpose that has been removed. And then there's an amended notice of motion. But the point I'm making, the point we make here is that even if regarded the sequence of events and all the notices of motions that have been served that's in the front of this court, none of them, steps have been taken in respect of none of them in terms of Rule 28 to have them amended. So the amended notice of motion can be regarded as pro non scripto, the one on 001 capital B. Because that's the one that they seek to amend. It says quite clearly in Mr. Sitando's notice of intention to amend. It's this amended notice of motion 001 capital B they seek to amend, but this is the same notice of motion that Mr. Sitando says has not been properly affected, and therefore we regard it as pro non scriptum. So that's the first point we wish to make. And if that is so, then this entire amendment falls flat. Because if regard is had to the amended as now sought, you can't even read the amendments into the original prayers in the notice of motion. It's just impractical to do that. So we submit that on this basis alone, the amendment should be dismissed. Secondly, it's incorrect for my learned colleague to say that we have condoned procedural steps or irregular procedural steps taken by his clients. But that is incorrect. This does not deal with procedure. I think the first issue, one looks at the first notice of motion, the one on 001, where your ladyship, Justice Scholars, correctly showed the defects in that notice of motion. Notice of motion does not say it will be supported by any affidavit by any stretch of any interpretation. This notice of motion is defective. What should the applicant could have done in exercise his law and right is to object in terms of the rules. But it did not do so. It filed an affidavit, so it cured that irregularity. But in any event, that is the notice of motion that stands. Now, the original notice of motion does not contemplate a review as submitted, as prayed for in the amendment. The reviews are completely, total different reviews. The current amendment in inverted commas refers to that amended notice of motion which has not been properly affected. That amended notice of motion refers to a different decision. And it's formulated completely differently from the review in the original notice of motion. The original notice of motion contained a 3 or 4 page affidavit where they make out their case. So if one is regard to the allegations contained in the papers, one would say that, and we rely on the De Beer case, is that they do not plead sufficient facts. They do not plead it succinctly. We do not know what case to call. The evidence is insufficient. And in the terms of the Beer's case, it's entitled, the court is entitled to dismiss an application which does not comply with the normal rules of constitutional, normal requirements of constitutional litigation. And it's not unheard of because it's similar to an exception taken on particulars of claim. But the same test is applicable here in this amendment because we say the amendments does not disclose a cause of action in any event. First of all, there's insufficient facts to sustain a cause of action, and secondly, the evidence suggests otherwise. So it's simply just a waste of time today to call us to court, all of us, after sitting and listening to argument for the last 3 days, to simply present a case formulated like this, with respect, my lady. The debate which this court had with counsel for the minister and for the other applicants doesn't even arise in this case because it's not been sufficiently pleaded. We've made that complaint in our heads of argument. It's been made. The complaint is in the affidavits before this court, and yet the respondents, Mr. Chitando, I beg your pardon, Mr. Chitando's clients, persist with this application to amend, persist with the ultimate, with the entire review. One has a sneak peek into the review as formulated in both circumstances. There's insufficient grounds pleaded, insufficient evidence presented for the minister to meet the case. So that's an answer, the short answer to this amendment, my lady. We've made other submissions in our heads of argument. We stand by the submissions. This is a complete abuse of process. Mr. Chitando's clients litigated in a reckless manner in this matter. It comes from the left wing, just launches, just files amended affidavits, amended notice of motions, and without seeking the leave of court, without seeking the permission of parties to amend notice of motion, and seeks then to invoke a right to amend which they don't have. And then when the amendment is poorly formulated, does not sustain a cause of action, and should be dismissed out of hand. With costs, my lady. My lady, in relation to, those will be our submissions on the amendment as argued by my learned colleague. Just one aspect, my lady, on the amendment on the permanent residency. I'll refer your ladyship to...
Sorry, Mr. Durance.
Yes. Yes, my lady.
Can you still hear me?
I do so, my lady. Can you hear me? Hello.
I can hear you, Mr. Durance. It seems like my sister is.
Sorry, I
unable to hear you.
just lost you there for a minute, Mr. Durance. My sound went off. You said
I beg your pardon, my lady.
you said you're seeking that that the entire application ought to be dismissed, given the manner in which the second applicant went about to amend here.
Yes, my lady. In relation to the PR, my lady, if one has regard to annexure, and I'll get you the reference AA21 to the minister's answering affidavit, and I wrote it down. Where we can find it, just give me 1 minute, please. It's case lines 004-106. Those if the court turns to the annexure, that is the permit which has formed the debate of, captured the attention of this court in the debates the last few days. And in that exemption permit, it specifically states that the permit does not give the holder the right to apply for permanent residency. So that is quite clear. So what the minister does is it grants an exemption and it provides a permit, and the permit specifically states on the face of it, it is limited in the sense that it does not give you a right to apply for permanent residency. It gives you a right to be present in the country, but it does not give you the right for permanent residency. So this legitimate expectation argument, which my learned colleague addresses in his, so what we address in our, what our learned colleague says in his papers and what we address in our argument is, does not even arise, because context is everything.
Mr. Jurans,
And
that, Mr. Jurans, can you hear me?
yes, my lord, I can.
Yes, it prohibits applying for what, residence or citizenship? Residence,
Permanent residence, my lord.
permanent residence for the duration of the validity of the permit. Is that correct?
That's correct, my lord.
Yes.
And we've heard the argument, and we know in common cause that those permits are still valid.
Yes.
And
Thank you.
that's that, and that forms the challenge of Mr. Ngaitobi's application yesterday. And so we submit that, my lord, my lord and my lady, my lords and my lady, that and a hopeless case has been made out for the relief sought. We submit that the application should be dismissed for the reasons advanced. We are mindful of the fact that BioWatch is applicable, but we submit that if regard is there to the conduct of Mr. Chitando's clients in this matter, that they be mounted with the cost order. So we submit that this application be submitted and that the remainder of the relief, including the striking out, that should just be simply be removed from the roll or be postponed sine die. We submit that this court does have the jurisdiction to do so because it has the inherent power to regulate its own proceedings, firstly. Secondly, if one has regard to the proposed order, which Mr. In the HSF matter together with the order of Mr. Ngaitobi, that those orders, should the court be with the applicants in that case, sufficiently caters the mischief which the Zimbabwe permit holders harbors in all the matters. So therefore, we submit that this application be dismissed with costs and the remainder of the relief, and including the striking out application, be postponed sine die. Unless there's any further submissions or questions from the honorable bench, those will be our submissions.
Yeah, Mr. Durant, I just want to see clarity. Look, we are faced with an application to amend, and you've made your argument as to why that ought not to be entertained by the court or granted by the court. So at best, what the court can do, if the court is with you, that's the respondents, is to refuse the application to amend.
Yes.
And then what remains is the application prior to the amendment then, prior to the proposed amendment that was moved.
Indeed, so my lady.
And you are saying you do not wish to proceed with your application to strike out today. Am I understanding you properly?
Yes, my lady, not today.
Yes. And you would want that to be postponed.
Indeed, so my lady. If one has regard to the matter, the matter before your ladyship and what transpired this week.
Okay. And then you would want the remainder of the application as it stands also then to be postponed.
Yes, my lady. And that would be the application found in case line 001-1.
Yeah. Okay. All right. Do you have any questions, Judge Malindi?
No, thank you, my sister. No questions.
Judge Mota?
No, no questions, my sister.
All right. Thank you. Thank you, Mr. Durans.
Court, please.
Advocate Chitando, do you have a reply?
Yes, Madam reply. The first point is that the respondents did not deal with the fact that they filed an answering affidavit. They filed that answering affidavit, I believe, on the 30th of April, and they answered all of the. They've answered the application, even with all of its challenges, up until the filing of the 15th of March papers. They filed papers. They have taken a procedural step. They have made out a case opposing the relief sought against them. And for that reason, it's disingenuous for the respondents to say that they don't know what case they have to meet. They do know what case they have to meet. Not only do they know, they have made out a case in quite substantial answering papers opposing the merits. And it's right in our law. I will refer, and I can refer the court to authority in this regard. This is right in our law. When a party, and this is considering, my lady, that injustices, this matter began in October 2021, and the respondents took no steps to make any complaints until the date of the hearing. And it gets even worse for the respondents in this regard. If one looks at the objections to the intended amendment, the objections only raise a objection to 2 prayers. They accept the first prayer. The respondents cannot accept the first prayer and then say that actually, after having heard the debate that I've had with the court, actually we should go back to the irregularity that was raised that they are now objecting to. So they're objecting to an irregularity more than a year after it took place, and they have filed several papers which don't make any mention of that irregularity. So they've made up.
I think, sorry, I think what, if I understand you correctly, you're saying they did not proceed to take a step in terms of Rule 30.
They didn't take, not just that Rule 30, my lady, you're quite right. Rule 30 is one of many rules that are available. In fact, my lady, if one looks at...
But they did file an objection to the proposed amendment, not so?
They did, but only in respect of the declaratory orders, not the review application, my lady.
Okay.
They did not object at all to the review application, and the review application for 3 decisions: the 24 November 2021 decision, the 5 January 22 decision, and the September 22 decisions. No objections were made to that. In the case management meetings that we've had, in all of the exchange of papers, all of the objections that my learned friend is making are being made for the first time now. And it goes against the principle of litigation that we that applies in our law, that after you've made all of these procedural steps, you can't then go back to the beginning and say there was a problem. They've acted on the papers we filed them, and in regard to the review application, which is the biggest application, they didn't object at all. The next point that I'd like to quickly make is that of the pleadings. My learned friend referred to a test that doesn't apply in de novo applications in motion proceedings. That is a test you mentioned. De Beers, you also mentioned, even in the heads of supplementary heads, the Crown Restaurant versus Gold City Reef and Phillips. Those are constitutional court judgments where the matter came before the constitutional court, and at a high court level, in all of those matters, the high court level, no constitutional issue was raised at the high court, but only when it got to the constitutional court and it gone through also the Supreme Court of Appeal, the applicants there decided to make a constitutional case. That is the authority that applies in this matter. It provides authority for class evidence in dispute of fact proceedings. All of the order that the applicant seeks to make an order of court, all of everything in the prayers that are before the court are supported, if one looks at my heads of argument even, are supported by the respondent's own admissions. So what my learned friend is trying to do is to say that, well, now he can now almost withdraw those admissions on the merits, and by raising raising the fact that the amendment wasn't properly effected, and the amendment was not properly effected for the reasons that we have already argued why that was the case. So, my lady, what I am proposing is that what I think is in the interest of justice is that in regards to the review application, the respondents from the word get-go answered the papers, they filed heads of argument, they even filed a Rule 65D notice where they wanted to take points eliminate, and none of the points eliminate in the Rule 5D notices before the court raised any of the objections that my learned friend has made today. In fact, before early this morning, my learned friend spoke to me, and it is obviously was on record at the beginning that the Rule 65D notice, which was also filed more than a year late by the respondents, has been taken back. And my lady, when my learned friend spoke about the conduct and proceedings, if one looks at the fact that even on a condemnation level, the respondents didn't file any papers on time, and they were supposed to move in a condemnation application today, and the applicant, because the applicant wanted the hearing to take place within time, allowed, well, basically we do not oppose the condemnation application. This speaks to conduct of proceedings. Also, my lady, may I refer you to the, I think it's case lines 004-13. That is that takes the court to the respondent's answering affidavit, more specifically paragraph 14, where the respondents say that no, this should be a Rule 53 application, and they oppose the fact that the applicants use Rule 6 and not Rule 53. That has all been pulled back. Even so, that demonstrates to this court that even at the stage of filing their answering papers, they were taking procedural points. They're answering.
Yeah, but I think, Mr. Chitanda, we're not going to rehash the entire argument now. You've taken up the better part of the day with your argument. You have an opportunity to reply, and please confine your reply to what has been raised by the respondents here. They're saying to the court, there's no merit to this proposed amendment that you wish to move here. The court should refuse that request to allow the amendment. And then they say for their application, their interlocutory application that's pending, they would do not have a problem if the court is to proceed to postpone that application, that other interlocutory application, that is the striking out of certain paragraphs contained in the replying affidavit, and then for the remainder of the application then to be postponed. That's what they're saying. So we're not going to traverse the entire argument that you've placed before the court earlier on. I think you need to appreciate the fact that we've sat here the better part of the day listening to the applicants.
Yes, I apologize, my lady. All I was doing was referring, my learned friend made mention to conduct and proceedings. I was just referring the court to.
Yeah, but it does not really take the matter any further. What we need to understand is, are you persisting with the proposed amendment? You still say there's merit in it and the court should grant it. That's all I want to hear you on. And I certainly want to hear you on cost, because there's a request now that the court should actually order you to pay the cost.
Cost of the amendment application.
Yes, because you're supposed to tender that. You didn't do it. You haven't complied with 28. Well, that's your own concession. So what do you say about that?
Yes, in a situation like this, the cost for the amendment application is always be on the applicant.
Okay, so you don't have an issue if the second applicant is ordered to pay the cost.
Well, my lady, my issue is the applicant is the one who's applied for the amendment, and the cost for it follow the result. But the applicants have been put in this situation. And that's what I meant. The applicants have been put in this situation because of several changes that the respondents made in their decisions regards to the city.
Anything else in reply?
On the amendment, no, I don't have anything else.
Judge Malindi? Any
No
questions?
questions, my sister.
Thank you. Judge Morton?
Sorry about that. I don't have any questions.
Thank you. All right, it's now 15 minutes before the hour of 3. Can we just have a short adjournment to consider the application to amend? And then we'll head down a ruling thereafter.
As the court pleases.
Thank you. Okay. Mhm.
But actually, the easiest way to deal with those documents is to withdraw that woman as a witness.
Yes.
Thank you, my lady.
Thank you. All the parties online?
The parties are online, however, I'm not certain if the other justices are, judges are online yet.
Okay.
Should we wait a few minutes for them, Judge?
Yes. Thank you.
I'm just waiting for Judge Manidi to join the platform. May it please the court? I confirm resumption of proceedings for case number 51735 of 2021.
Thank you. We have, as the bench, considered the submissions made for the better part of today in respect of the application by the applicants to formally amend their notice of motion. We have concluded during our brief adjournment that in order to do justice to the merits of this application, as well as the importance of the application to the parties concerned and the urgency of this application, that it would be prudent rather to reserve our ruling. We are aware that the litigants before court, especially the applicants, would want to have finalization of their pending application before the date of the 30th of June 2023. So we will have that in mind and keep that in mind. And for that reason, we are going to reserve our ruling. We will inform the instructing attorneys on either side as to when the ruling on the application to amend by the applicants will be handed down. And then we'll give directions as to how the matter is to proceed. So the court's ruling is then reserved. And you are then all excused. Thank you.
As the court pleases.
The court, please.
Thank you.